Hi, everybody. Matt Chalmers here, CEO of Birch Citadel. And I want to talk to everybody today about something that's been in the news lately. I just couldn't let this one pass by. This is the United States Supreme Court recently overturned one of the core pillars of environmental law for the past 40 years, which is called the Chevron case, and then what's referred to as the Chevron Doctrine or Chevron deference. This sent shockwaves through the entire environmental law community, and I want to try and break it down in a way that's accessible to everybody listening here. Let's get into it. Okay, so when we're talking about Chevron, what this doctrine said, and when I'm talking about a doctrine, what I really mean is this is a rule that is in place not from a constitution, not from a statute, not from a regulation, but it's a rule that's coming out of case law. So this is a judicial made rule, and this is really like the nuts and the bolts of how the machinery of law actually operates. So we're going to be getting really deep into the weeds and how this thing works. In a nutshell, what the Chevron Doctrine said was, hey, where there's a statute that provides an administrative agency the authority to do something, if there's an ambiguity in that statute, then essentially the courts need to defer, at least to a certain extent, to the expertise of the agency that's tasked with implementing that rule. So this kind of gets to the heart of administrative law and how administrative agencies have the power to do the things that they're going to do, and how courts interact with that, and how that plays out, for example, in a lawsuit environment where there's an argument about the extent of the authority that the administrative agency has, or whether something that they're doing is within the scope of that authority. So in order to make sense of that, let's step back and let's do a little bit of administrative law 101. And this is, by the way, if you're a law student watching this, I'll tell you the same thing that I've told every other law student and every other legal intern I've ever mentored in the course of my career, which is, yes, I know administrative law is not technically a bar course. You're not technically required to take it. Treat it like a bar course. Please, please, please take administrative law before you leave law school. It will make your life so much better because it's such a huge component of virtually any practice of law where you're going to be dealing with an administrative agency. It's really important that you understand how that works. Okay, Admin Law 101. Let's talk about sort of the structure of law. So we all know that we start with, there's a constitution, whether it's a state constitution or the federal constitution, with the authority flowing from we the people. That constitution is going to create a system where you've got, for example, the legislature, you've got the courts, and you've got the executive, whether that's the governor or the president. From that constitution, from that operation of how laws are constructed, you're going to get statutes that are passed by your legislature and are approved by your chief executive. So that's how you're going to get, for example, the California Public Resources Code. That's the volume of laws that have to do with, for example, the environment. Then what you're going to see is you're going to see there are administrative agencies that are set up by operation of law. We first experimented with this, over a century ago at the turn of the 20th century, a little bit after that. That's when we sort of set up this notion of the administrative state. That came out of, really, it was a practical decision. The set of laws that we had on the books were so complicated that it was beyond the skill of legislators to implement all of the various details. We needed specialists who had the training in those areas to sit down and actually think through how all of the different regulations needed to be promulgated, what they needed to be. So out of that, we sort of have a natural extension of the way committees work in legislatures, where there's just too much to do for every individual congressperson or every individual senator to understand how all of the laws work in their head. Yes, everybody needs to pay attention when they're voting, but you need people to specialize because otherwise there's just too much to do and it's too complicated. So that's how we got legislative committees. This is just another extension of legislative committees, but it reaches out into the executive branch. Okay, so what we've now learned is an administrative agency is set up because the legislature says, hey, we've got a problem that needs to be solved. Let's say we'll take something really basic, traffic. Traffic and transportation, there's a lot of things that we need to do to make sure that airplanes and boats and cars are safe. We need to make sure that they're efficient. We need to make sure that there's just this enormous number of problems that need to be solved. And those problems need people with expertise in how to solve those problems working on it. So instead of Congress sitting down and saying, well, we're going to spend all of our time and write out all these regulations, no, what we're going to do is we're going to create an agency where there is that level of expertise, and we're going to give them a mandate and we're going to give them authority. So we're saying, hey, dear, National Highway Traffic Safety Administration, let's use the NHTSA as an example. Hey, we're going to say your job is to do this and this and this and this and this. And sometimes those statutes are very prescriptive, like specifically your job is this and this and this. Or sometimes they're broad. Hey, we want you to figure out this problem. And then we're going to give you budget. We're going to give you explicit power to promulgate regulations that take care of all these different problems. Okay, fantastic. Now you're in a situation where you've delegated the expertise and the authority based off that expertise to that administrative agency to go, do what they need to do within the bounds of what's created by law. So with every administrative agency, there's always that list of powers that they have. And that agency can't do something that's outside of those delegated powers. The statute hasn't given them the authority to do more than that. So that's sort of the core concept. Okay, so where does Chevron come in? So over the course of years and years and years, as these agencies grew in complexity, because there's a lot of problems and we needed them to go solve these problems, and there's always arguments over, did the agency go too far? Did they not go far enough? There's going to be problems on all those different sides, but at the end of the day, okay, we got to a place where agencies have an enormous amount of expertise in-house, more so than the legislature, more so than the governor, et cetera. What Chevron recognized is, hey, the agency is actually going to have more expertise and more familiarity with their statutes than, in some cases, even the courts might have expertise with their statutes. But the courts, at the end of the day, as they have to be, and just from a practical standpoint, this makes sense. The courts have to be the ones that are in charge of interpreting the law. They have the expertise in doing their job, interpreting the law, making sure everything is constitutional, making sure, yeah, this is within the scope of the statute or not. But the courts are usually generalists. Yes, there's some circuit courts, for example, the DC Circuit Court of Appeals tends to handle a lot of regulatory cases, so they've got some expertise with that. But generally, courts are generalists. So even in the context of a lawsuit, the agency is going to have a lot of particular expertise. Okay, so Chevron deference doesn't mean the court is going to sit there and absorb the words of the agency as like, this is the ultimate truth. No, 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 no. What Chevron said was, hey, we're going to go through a process. And at the end of that process, to the extent that there's an ambiguity, courts are required to take into account what the agency has said and give it some level of deference under certain circumstances. That's the Chevron Doctrine in a nutshell. So what the recent ruling that came out of the US Supreme Court said was, okay, hold on. We're not going to do that anymore. Courts now no longer are required to defer. They're no longer required to take into account what administrative agencies are saying. So we've backed away from that, and we've given courts back the power that they initially had before Chevron to say, all right, the courts are the ultimate arbiters here. And what the agency says might be persuasive, but the courts are no longer required to listen to it. Here's what that means in terms of the big picture balance of power. So as we look out into the field of how this plays out in the real world, administrative agencies are usually trying to accomplish their objective, and they've got a massive amount of expertise. They're trying to solve something that's really complicated, and the toolbox that they have to solve those problems are implementing their regulations. So they've been given a mission, and they're going to go off and they're going to do their mission. Sometimes they do too much, sometimes they don't do enough. It's going to vary case by case, and whether they're doing too much or too little is going to depend entirely on who you ask, because we have a beautiful and wonderfully complex world that we live in with thousands, hundreds of thousands, millions of different stakeholders that have different interests. And the things that different folks value and the things that different folks are trying to accomplish, different folks are able to accomplish, that's going to vary all over the place. So if you are a consumer and the thing that you care about is making sure your products work, you're going to have one set of interests. If you're somebody that's living next to a factory, you're going to have a different set of concerns, probably environmental. If you live 100 miles away from a factory, you might not care and you're just worried about the general market price. If you're the company that's making the things, you're going to have a very different set of concerns that are driven by your bottom line and whether you're profitable or not. So all of those different concerns are valid. And how valid they are is going to depend on who you ask, because different people have different priorities. Okay, so agencies are left holding the bag to figure out how to make sense of that mess and do the right thing given their legal authority and their mandate and their resources. And the courts are left doing the same thing. Here's what this ruling has changed. The typical battle that you're going to see is regulators from administrative agencies are going to try to accomplish their goals, and companies that are being regulated are going to try to push back. So most of your lawsuits, you're going to see this happening between the two of them, and there's going to be interveners that are going to be jumping in. Various nonprofit groups, for example, environmental groups are going to say, hey, we care about reducing emissions or water discharges or whatnot. Consumer safety groups are going to come in and say, hey, we care about making the right product, and just do the thing that's going to make sure that the product comes out correct. And all of those different stakeholders. What this has done is it's taken away a lot of the tools that the administrative agencies have to push back in lawsuits. So now the balance of power is shifted, and we're now going to see in this world folks that are attacking the regulations made by administrative agencies are going to have more power to say, hey, we don't think those regulations are consistent with statute. Hey, we don't think that the action that you took implementing or enforcing those regulations is consistent with statute. And the agency might say, well, we've been doing this for 34 years and there was never an issue before. Well, now there is, because just because you've been doing it for 34 years, just because you have all that expertise, it's only persuasive right now. It's not something that courts have to defer to. So we should expect to see that there's going to be less regulation, not just in terms of what's existing and what's being challenged, but now we're going to see less bold action coming out of administrative agencies, which if you're somebody who's being regulated, you might really like that as a stakeholder. But if you're somebody that benefits from the problem solving that administrative agency is trying to do, well, the agency's not going to be on as firm ground now to try and solve those problems. Agencies are going to be a little bit more, or in some cases a lot more, on the back foot. We're going to see more conservative, not like politically, ideologically liberal versus conservative, but conservative legal practice is what I'd expect to see out of agency rulemakings moving forward, where they're going to do less, they're not going to push as far, and they're going to make sure that whatever they are trying to do is really clearly within the bounds of what their statutes authorize them to do. So I would expect to see a retreat on part of administrative agencies, or those agencies that are going to continue to push forward and continue to say, no, we're not going to be slowed down. I would expect to see more lawsuits coming their way, and probably more lawsuits that are going to be successful. Now, this is, of course, a super, super high level assessment. Your mileage may vary. Anybody who's, of course, administrative law practitioner who's listening to this understands, boy, I glossed over an enormous amount of detail. And there's going to be a lot of case by case differences that are going to occur in, what statute are you working with? How explicit is that statute? Things might not change as much there. Where the statute is more squishy and general, I'd expect to see larger changes there. And it's going to depend on what are the different stances the different agencies have taken. Are they working with their stakeholders? Are they constantly under threat of litigation? All of these things are going to vary across the board. There's a lot of diversity in the country on this. But if you were wondering what's up with all that Chevron stuff happening in the news, why is the environmental law community going, holy moly? Why are regulators going, oh boy, we got to adjust to the new world? Now you've had a very quick crash course in admin law, in Chevron Doctrine, and in, well, everything that's going to be happening in the future and what I'd expect to see happening in the future. Thanks everybody for listening. This is Matt Chalmers, and you've been listening to Birch Talks. Have a great day. Cheers.